Good afternoon, everyone. My name's Tom Luckymeyer, and welcome to our webinar on last week's Supreme Court decisions on the OSHA ETS. We're going to wait about 15 seconds or so as the queue fills up, and we'll be starting promptly, probably a minute from now. All right, we'll go ahead and get started. As I said, this is Hinshaw's webinar on last Thursday's Supreme Court decision on the OSHA ETS and the CMS interim rule. And those of you who have participated before on Hinshaw Matters and webinars know that we try to have a heavy emphasis not only on the practical ramifications, but give you some very good legal advice as well as to what these decisions mean. I'm going to introduce my two co-speakers, my partners, Lee Bonsall and Dana Weinstein. Dana's from the Fort Lauderdale office and Lee is here in Chicago. Last week, we provided a webinar on navigating the various COVID regulations, and mainly on the federal side. And approximately 2 hours after that webinar concluded, the Supreme Court released their two decisions. And as a result, the questions have changed. The first question is, now what do healthcare facilities have to do in order to address the CMS interim rule? And the second question is, what's next for OSHA? And we're going to answer both of those questions for you during the course of this webinar. The order of what we're going to do is very simple. I'm going to briefly recap the Supreme Court decisions and the underlying rationale from last Thursday, followed by Dana, who will talk about the CMS interim rule, which obviously survives. Lee will talk about state, local, and employer initiatives and how they may be affected by OSHA. And I'll borrow a phrase from George Lucas. We'll have to see how the empire strikes back and what OSHA will do with respect to the with the ETS and whether there'll be new regulations on the horizon. So let's talk a little bit about what happened last week. And here's where we stand. Put simply, enforcement of the OSHA ETS has been stayed and will remain stayed pending a decision on the merits of the challenges to the emergency temporary standard. I'll call them the ETS. The High Court dissolved the stay. In other words, CMS can move forward with the enforcement of its interim rule by the Centers of Medicare and Medicaid Services. I'll refer to the Centers for Medicare and Medicaid Services as CMS. Now, the CMS interim rule was returned to the Fifth and Eighth Circuits for additional proceedings, and the OSHA ETS was returned to the Sixth Circuit for additional proceedings. Next, please. So 2 matters were at issue. The decision on the OSHA ETS was decided 6-3 to reimpose an injunction on the enforcement by OSHA. Breyer, Kagan, and Sotomayor dissented. The decision on the CMS interim rule was a closer call. It was decided 5-4 to stay the injunction, which means the injunction was removed. Justice Thomas dissented, and he was joined by Justices Alito, Gorsuch, and the newest justice, Justice Barrett. As we said before, both cases were returned for further proceedings. If you want to make it very simple, the OSHA ETS is stayed, and the CMS interim rule is not stayed. Next slide, please. So what is behind the court's decision on ETS? Well, an obvious point the court made is that OSHA can only exercise that authority which Congress provided in the Occupational Safety and Health Act. There was a lot of discussion in the court as to the amount of delegated power that's provided to federal agencies. And the court noted that this was no everyday exercise of federal power. In fact, it was quite extraordinary. The court expects Congress to speak clearly when they are going to authorize an agency to exercise powers of what they call vast economic and political significance. And if we wanted to phrase it in terms of an issue for those lawyers on the line, the precise legal issue raised by the court is whether the act plainly, and when I say the act, I mean the Occupational Safety and Health Act, plainly authorized the Secretary of the Department of Labor to issue the ETS they did, given the breadth and scope of the proposed standard. Next slide, please. The answer is no. The court found that the OSHA Act authorizes the Secretary to set workplace safety standards and not public health measures. They found no provision within OSHA which permitted the Secretary to address generally public health issues, and permitting OSHA to regulate what they said are the hazards of daily life, simply because most Americans have jobs and face the same risks while on the clock, would significantly expand OSHA's regulatory authority, again, without clear congressional authority. The court found significant the fact that OSHA, in its roughly half century of existence, actually 51 years, never before has adopted a broad public health regulation of this kind. Next slide. The court also noted that prior efforts with respect to emergency temporary standards most often didn't survive legal challenges. It's either 9 or 10, I think I've lost count, as in the last 50 or so years, how many times OSHA has promulgated an emergency temporary standard. In those 9 or 10 times, only 2 have survived legal challenge. And this OSHA ETS is no different. The grave risk standard necessary to sustain an ETS is difficult to overcome. It's a high threshold. And the preference by Congress, and obviously by the courts now, is for customary rulemaking with notice and comment to be used, and not necessarily an ETS in this situation. In summary, the courts found that the equities do not justify withholding interim relief. In other words, a stay on enforcement. Now, the court's comments with regard to the ETS will provide useful instruction to the Sixth Circuit, and it's going to be hard to see how the Sixth Circuit could pass the ETS back to the Supreme Court and expect that they'd have a different result. I fully expect that the OSHA ETS will not survive even in the Sixth Circuit. Next slide, please. Now let's go to the Supreme Court's decision on the CMS rule. It's important to contrast this case from the OSHA ETS analysis. Unlike OSHA, where the court found the department went beyond workplace hazards, occupational hazards, in other words, to deal with public health issues, we all know that CMS has regulated healthcare entities in this very space. CMS has long included requirements that providers maintain and enforce, for example, an infection prevention and control program, which is designed to either eliminate or limit the transmission of communicable diseases and infections in hospitals and other types of healthcare facilities. Next slide. And so how the interim rule works is it amended the existing conditions of participation to add the requirement that facilities must ensure their covered staff are vaccinated against COVID-19. The court agreed with the federal government that the interim rule falls within the authority that Congress has provided to the Secretary. For example, the court found that Congress has authorized the Secretary to impose conditions on the receipt of federal funds that are necessary to promote the health and safety of individuals who are furnished services within a healthcare facility. In other words, patients. The court also found that the Secretary often or routinely imposes conditions related to the qualifications and duties of healthcare workers. We all know, anyone who's represented healthcare entities over the last several decades, that vaccinations are often mandated and include things such as hepatitis B, influenza, measles, mumps, and rubella. Next slide. It was for all these reasons, and this is really a summary of why the court ruled the way it did. But the court held that the Secretary with respect to the CMS interim rule did not exceed his authority by conditioning eligibility of a provider to participate in Medicare and Medicaid on its employees being vaccinated. The court also noted that its role is simply to ensure that the agency has acted within a zone of reasonableness. And if you want to compare both decisions, it's clear that the court found that with respect to the OSHA ETS, the court did not act within a zone of reasonableness and outside of its authority. Dana, I will turn it over to you.
Thank you, Tom. So I'm going to be discussing what healthcare facilities actually have to do to comply with the rule that is now enforced in all states except for Texas at this moment. So there are 4 different categories of healthcare facilities that are subject to the rule if they are regulated under the Medicare and Medicaid health and safety standards. So this includes hospitals, outpatient rehab facilities, hospices, long-term care facilities. Altogether, there's over 20 something different types of entities that may fall under this rule. I just want to point out that physicians' offices are not regulated by CMS, so they would not have to comply with the vaccination mandate. But if they were to offer services such as physical therapy or speech therapy, they may then fall under the rule. So facilities should make sure that just because they may think initially they don't fall under the rule, that certain services they offer may subject them to the rule. Next slide, please. So Tom mentioned the conditions of participation and that the rule changed the infection control measures currently in place in those facilities I went over. I am going to first be focusing on what staff are subject to the rule. Generally, any staff that interacts with patients, of course, fall under the rule and need to be vaccinated or get an exemption. Additionally, staff that maybe don't have direct patient contact but interact with other staff need to be vaccinated as well. So this will include employees, any practitioners, students, volunteers, anyone employed even if they're on a contract basis. So a rule of thumb to keep in mind is that any employee that has the potential to perform at the site of care should be vaccinated or get an exemption. Additional conditions that were added are that their hospitals need to develop procedures to put in place to make sure those that are not vaccinated do not transmit COVID-19 within the facility. Vaccines and exemption requests need to be documented, and there needs to be a contingency plan in place for those that are not fully vaccinated. And just to quickly mention, there's only 2 types of exemptions that CMS is allowing. One is a medical exemption and the other is a religious exemption. I'm in Florida, so there are currently laws in place in Florida that private businesses need to offer all of these different types of exceptions. So providers in Florida are in a little bit of a tricky situation figuring out whether to comply with the state or federal law, but it would be best to try to comply with both if possible. Next slide, please. So the survey process. This is going to begin at subject facilities either on January 27th or February 13th, depending on what state you're in. So it's going to comprise of 2 different steps. The first step is the entrance conference, where the surveyors are going to review policies and procedures. And hospitals are going to have to put in place quite a few different policies. So one is going to be when are the vaccination deadlines? Infection control measures, particularly for staff that are not vaccinated, tracking and documenting the actual vaccination records for staff and booster shots, the process to request an exemption, documenting clinical contraindications for medical exemptions, tracking those that have to delay the vaccine for one reason or another, and contingency plans for and deadlines for people to become vaccinated. So the hospital is going to provide a list of all staff and their current position, as well as staff that are not vaccinated. And they also need to keep a list of staff that have been hired in the past 60 days. Then when the surveyors get to the record review process, they are going to interview employees and they're going to observe the facility itself. So I first want to mention the contingency plan that I mentioned before. So if staff are not vaccinated, the hospital needs to accommodate those individuals. So they can place those employees in remote positions or in positions where they're not having as much patient contact or with people of a lower risk level. They need to wear face masks and physically distance, possibly get weekly testing or wear N95s for the duration of the time that they're at the facility. And those are just suggestions from CMS. They're not requirements, but they are in the guidance documents for the hospitals. So surveyors are going to look at unvaccinated staff documentation, all different types of employees, whether they're on staff or their contract, and they're going to look for discrepancies. So if an employee has marked that they have a contraindication on their record, whatever that contraindication is needs to match when they actually go to interview that employee. They're also going to look for, did the hospital educate the employee as to the importance of the vaccination if they did not receive it, and were they actually offered the vaccination? Finally, they're going to be looking at infection control measures, and all of these will come into play later with the deficiency letter if there is one. Next slide, please. So if the hospital finds a deficiency during that process, there are 3 different levels that they may rate the hospital. A standard level deficiency means that either 100% of people are vaccinated, but there was just one policy and procedure that was not implemented, or that maybe there's not 100% compliance, but the hospital made a good faith effort to comply. And I'll define that later on. A condition level is a little more serious. It means the hospital did not meet the 100% requirement, and maybe one policy and procedure wasn't developed, or possibly 21 to 39% of people remain unvaccinated. For the final level, that's immediate jeopardy, and that is 40% or more of people are unvaccinated, or possibly you're close to 100%, but there's not good infection control measures in place for those that are unvaccinated. For long-term care facilities, the ratings are a little bit more complex because they're not only looking at rates of compliance with vaccines, but they're also looking at infection rates combined with the severity of illness that are going on among staff and residents of those facilities. For both facilities, I mentioned the good faith effort before to comply. So if the facility has taken aggressive action and they've hosted vaccine clinics and they've really encouraged vaccination among their employees, then CMS may give them a lower citation level and a lower enforcement action in that case. Additionally, if there were supply chain issues, CMS would take that into consideration. So if the facility received the letter of deficiency, they would then respond with a plan of correction. And of course, CMS is just looking to have staff vaccinated and have policies and procedures in place. So if after all that happened, most of the staff then get their first vaccine and they're scheduled for their second dose, CMS would clear the citation and the facility would be considered in substantial compliance. If some staff got their first vaccine and other staff are scheduled, then the citation would remain, but the facility is still considered in substantial compliance. Immediate jeopardy, which that was like the 40% that I mentioned earlier, unvaccinated, the facility needs to correct gaps in their policies and procedures, implement a contingency plan deadline for staff to get their first dose, and put additional precautions in place to prevent the spread of COVID-19. Next slide, please. So CMS's goal, as you can see, is to bring the facility into compliance, for this facility to come into compliance. They are not looking to terminate right away. Generally, the facilities can continue operations except for that immediate jeopardy that I mentioned, which only would allow 23 days to correct the citation. Next slide. So the deadlines. So I mentioned 2 different sets of deadlines. It depends on whether your state falls within one of the states that were a part of the litigation that just went to the Supreme Court. If your state is one of those states, the deadline is a little bit later on, February 13th. So that first 30-day deadline, whether it's January 27th or February 13th, that is when surveyors are going to start coming to the facility. So there should be 100% compliance by then. But if there's not, as long as the facility is above 80% and there's a plan to get to 100% within 60 days, there will not be additional enforcement action. The 60-day deadline, February 26th or March 15th, if the facility isn't still not at 100%, but they're above they're above 90 and they're going to get to 100 within 30 days, then there will not be additional enforcement action. And then at the 90-day mark, there needs to be 100% compliance with the rule. Next slide, please. So documentation, this is going to be very important for when the surveyors come to the facility. So of course, the facility needs to document vaccine and booster records, but the exemption requests and outcomes are very important because the medical exemption requests need to be very specific. They need to be, of course, signed by a practitioner that the person has a contraindication to the vaccine. And they need to list what the clinical reason is for that contraindication. And it's to each individual vaccine. So if there's something in the Pfizer vaccine that you're allergic to, but it's not in Moderna, the person needs to receive the Moderna vaccine. And just so you know, CMS only discusses severe allergic reaction as a medical reason for getting an exemption. They do direct to the CDC, which discusses different conditions in more detail and how the provider should go from there. But for example, if somebody is pregnant, the CDC says that those people should receive a vaccine. So it's quite specific as to what is allowed. The religious exemption, on the other hand, surveyors are not going to look at the details of the request, and they're not going to look at whether the hospital should have approved the request or should have denied the request. They're just making sure that there's an effective process in place for someone to get that exemption. Additionally, delays. If someone was sick with COVID-19 and couldn't get vaccinated, or they received antibody treatment, there needs to be documentation as to when that person will resume their vaccination series. And then I mentioned the contingency plans before. So that's someone's going to undergo weekly testing in lieu of vaccination. All of that needs to be documented for each staff member. And those are the general rules for hospitals to follow when implementing this rule. And Lee, I think, yes.
All right, thanks so much, Dana, for that. Good afternoon, everyone. So Dana has covered the requirements for employers subject to the CMS rule. I am now going to go through some considerations for employers not subject to the CMS rule in terms of implementing or maintaining a vaccine mandate policy. So with the Supreme Court ruling on the OSHA ETS, we now know from Tom that there is not at the moment a requirement at the federal level for large employers to have a vaccine or test policy. Generally speaking, employers are able to create their own policies, and I know there are many employers who had their own vaccine policies prior to and without regard to the ETS. However, I'm going to go over some considerations employers should make in regard to these types of policies, depending on their circumstances. So first of all, in the decision tree analysis, if you're subject to the CMS rule, you have to follow the requirements that Dana just covered. Next, if you are not subject to the CMS rule, one consideration is whether you are a public or a private employer. Public employers with vaccine mandates have faced constitutional challenges, and those so far have been rejected by courts. For example, there was the Trugstad case here in Chicago that was based on mandates issued by the governor of Illinois and by the mayor in Chicago. The case was filed by a group of city employees, and one of their claims in that case was that they had kind of a substantive due process right and a fundamental right to their bodily autonomy. The court rejected that argument based on a 1905 Supreme Court case that held that a Massachusetts law that required residents to be vaccinated for smallpox was permissible, and that was permissible under the state's police power. And the rule was legitimate based on evidence that was submitted from local health boards. The same was true in the Illinois case, where there was support from medical professionals for the vaccine mandate. So the court rejected the employees' claims in the case here in Chicago. So that's just an example of the types of constitutional issues that can be raised in the public context. Those would not be an issue for private employers. It also kind of brings up an interesting contrast to the Supreme Court's recent opinion when we look at who the actor is. So the old 1905 precedent had to do with the state's police power, where in this most recent opinion, the court was looking at OSHA and its statutory mandate. A third consideration beyond public or private employers will be whether the employer is in a unionized workforce or not. So in the unionized context, if an employer would like to implement a vaccine mandate, either it will need to be negotiated with the union or potentially it could be implemented unilaterally, and that will really depend on the language in the collective bargaining agreement. So the right to implement the mandate unilaterally would likely come from a management rights provision, and the scope of those clauses vary from CBA to CBA. This analysis of the CBA may have changed in light of the Supreme Court ruling. So some CBAs provide a right to management when confronted with a new legal obligation, and the ETS would have satisfied that condition and provided employers with that cover, but that no longer exists. So without the ETS being enforced, employers will need to review the management right provisions in their CBAs to determine if the right to mandate a vaccine can be achieved without bargaining, without a significant risk of an unfair labor practice charge. In addition to considerations of whether an employer is a public employer or a private employer, unionized or not, in light of the Supreme Court ruling, it's important for employers to now really consider the state and local jurisdiction and what rules apply. So for example, an employer here in Chicago would need to consider the Illinois Executive Order 2021-22. And this is a vaccine policy that applies to healthcare workers and school personnel, higher education personnel and students, and also state-owned congregate facilities. So that would be a first consideration. Also, Cook County has a vaccine mandate that's applicable to employees, volunteers, interns, consultants, contract personnel, and independent contractors. The city of Chicago has a vaccine or test rule applicable to employees, contractors, and vendors. And in addition, both the county and the city recently issued mandates requiring restaurants, gyms, and entertainment venues to require proof of vaccination for anyone 5 and over. So the point here is that employers and businesses may still have various mandates at the state and local level that they still need to comply with, even absent the OSHA ETS, depending on the nature of their business and the industry they are in. Employers should also check their state labor departments to see how those agencies are handling any rules they had proposed based on the federal ETS. So here in Illinois, what's shown on the slide is what is on our Illinois Department of Labor website. The department basically issued this statement that says it will follow the feds and stay enforcement of its rule, but that should be checked no matter what your jurisdiction is. Making things even more complicated, and Dana hinted at this a bit, is that in contrast to Illinois, where there are different vaccine mandates in place, some states have policies that limit employers' ability to mandate vaccination. So with the Supreme Court ruling, employers need to be even more aware of these state laws because they no longer have the federal ETS as cover. So in Florida, for example, that Dana was referencing, a law was passed by the governor that requires employers that have a vaccine mandate policy to have very expansive exemptions to the mandate, including the ability for employees to opt out of the mandate altogether if they agree to test. So you know, based on Dana's presentation, that as written conflicts with the CMS rule. So if you are an employer navigating that kind of conflict between the federal CMS rule and a state law, it would definitely be a good idea to reach out to an attorney to talk about the best ways to mitigate the risk in those circumstances where you're dealing with these opposing constraints. Another thing to note where state and local law may end up filling in some gaps created by the lack of enforcement of the ETS is in regard to paid time off for employees to get the vaccine or sick time to recover from the side effects. Those were both provisions that were in the OSHA ETS that are no longer being enforced, but employers should be on the lookout for any state or local law that may pop up to offer those kind of benefits. So to kind of recap so far, employers who are grappling with vaccine or testing mandates should first consider whether they're subject to the CMS rule. If not, consider your status as public or private employer, unionized or not, check state and local law. And then one final consideration is for those of you who are federal contractors or subcontractors. An important thing to note is that the Supreme Court ruling did not address the federal contractor mandate, which was issued separately through an executive order. There were also legal challenges to the federal contractor mandate in different district courts, and a nationwide injunction was entered by a Georgia district court. That was appealed to the 11th Circuit, and the 11th Circuit denied a request from the government to stay the injunction. So it's not currently being enforced. However, the merits are being briefed with the briefing schedule ending at the end of January. So there may be a ruling way towards the end of January or early February. So anyone who could be subject to that executive order should be on the lookout for that ruling. And with that, I will turn it back over to Tom.
Sure. We gave a prediction last week with regard to OSHA ETS and the CMS interim rule, and our prediction was accurate. I don't know if we should press our luck, Lee and Dana, but with regard to the 11th Circuit decision, I'm going to predict that they will not support the government on the merits. After all, the executive order is really about procurement of goods and services and addressing, again, a public health emergency may be outside the scope of authority of an executive order, but it's an executive order as opposed to an OSHA interim rule. It's an executive order as opposed to a temporary standard. So we'll just have to keep our eye on that one, but I don't think the executive order will survive either. It's not surprising that a lot of the questions that have already come in on the chat have been about the accommodation requirements. And the most important thing to remember is that for the private employers out there and even the public employers out there, the accommodation requirements didn't go away with the court's decision on ETS. And that is a key point. To the extent an employer has a mandatory policy regarding vaccination or testing, that could trigger a request from one of your employees for an accommodation. And the accommodation requirement for sincerely held religious beliefs is a long-standing requirement of Title VII, back from the early 1970s is when the most of the case law was first developed. And the accommodation requirement for disabilities is a long-standing requirement of the ADA. And corresponding state laws for both religion and for disability. Next slide, please. Here's the best rule for you. Defer to your normal accommodation process. Require obtain documentation from the employee's healthcare provider to substantiate the condition and the restriction related to the vaccine. If your accommodation process requires the completion of a request form, maintain your normal process in the evaluation of those forms. There was a question from the audience about with regard to the use of the CMS forms. They were a mandatory vaccine employer already. Do they have to redo all the forms? No, is the general rule, unless the criteria utilized was really different from what CMS would prefer. Does that mean it's fatal? Of course not. CMS is looking to achieve compliance with the vaccination standard. They recognize the need to accommodate, and they want to make sure that you're employing the right criteria and not employing them so loosely or cavalierly that you're just allowing anybody to get an exemption from the vaccine. Sometimes it is appropriate to ask for information from an employee's healthcare provider with regard to how the vaccine may be contraindicated to a specific medical condition. The key is consistency. Please always remain consistent in the application. inconsistent application of accommodation requests could actually lead to other claims. It could lead also to retaliation claims. Next slide, please. We've gotten a lot of questions on what is a sincerely held religious belief. Quite frankly, I think it is a fool's errand to focus too much on what is and what is not a sincerely held religious belief, especially in light of the relatively low threshold for undue burden that we'll see under Title VII. Why is that? Because it could include everything under the sun. It includes both theistic and non-theistic beliefs. Agnostics could have a sincerely held quote unquote religious belief, even though they question the existence of a God. And that's because the EOC defines religious practices to include moral or ethical beliefs as to what is right or wrong, and whether or not those beliefs are sincerely held with the strength of traditional religious views. Think about it. If that's the standard, how is an employer ever going to prove that an employee does not sincerely hold the belief he or she professes in a request for accommodation? Keep in mind also that pursuant to the CFR, which is the Code of Federal Regulations, the fact that no religious group espouses such belief, or the fact that a religious group to which the individual professes to belong may not accept the belief is not determinative. An individual who is Catholic may say that my own beliefs prevent me from getting the vaccine, despite the fact the Pope has come out and said that it is appropriate under Catholic doctrine to get the vaccine. So keep in mind that for purposes of any analysis in this regard, religion includes not only the traditional 5 major faiths, but also faiths that are new, uncommon, or informal, and may include faiths which only have a small number of practitioners. So I think it's better to avoid the focus on sincerity of the belief and begin any analysis with the point of acceptance. This last point is key. Always err on the side of caution. The focus, especially with religious discrimination and religious accommodation, on the accommodation itself. That is key. Next slide, please. There are going to be times when a particular claim may strain credulity. In class, we talk about the cozy cat food case, where a woman professed that she belonged to a religious sect which required her to eat the same things as her pets, and therefore would bring in wet cat food every day. The court didn't rise to the bait, didn't accept that as a religious practice, but the fact that it actually got to a court is indicative of the fact that we really shouldn't be questioning those issues. Nevertheless, if an employer is aware of facts that provide an objective basis for questioning the sincerity of the belief, you can request additional documents to be used in the review process to further the assessment. Statements and explanations from the employee that discuss the nature and tenets of the belief, or information about when, where, and how they follow this practice or this belief. Written materials that may be available to the employee could also be requested. I talked before about, and by the way, written statements or other documents from third parties, do not begin with that. Do not require every employee who has a religious accommodation request to obtain a note from a pastor or a rabbi or another religious leader. Again, start from the perspective that the belief is sincerely held. I want to talk a little bit about the thresholds for undue burden. The ADA has a higher threshold for undue burden than Title VII. Under Title VII, which governs religious accommodation, any burden which is more than de minimis or imposes more than a de minimis cost on the employer or burden on a co-employee is deemed unreasonable. Unlike that, or contrast that to the ADA, where the Congress anticipated that there would have to be some cost incurred by the employer and some burden on co-employees. If you're dealing with a healthcare entity, for example, the Title VII religious accommodation is easily dealt with. It is an undue burden to expose patients and coworkers to an unvaccinated individual. That same argument could be made in the context of the ADA in non-healthcare facilities, for example, where employees are working closely together or members of the public. Employers have to be concerned about the safety and health of their employees. And when employees are exposed to the public and they're unvaccinated, it is the actual conditions of employment that could result in an occupational illness. Next slide, please. This will take us.
Tom, 1 second before we get to that, I just saw a question on addressing accommodation for vaccine, testing, masking, or all. So I think if you could describe kind of the difference in the analysis for an employer, if an employee is requesting just an accommodation from a vaccine policy and maybe there are alternatives, or if the employee is saying they're not going to, undergo the vaccine or testing or masking, and how those different requests would be handled by an employer.
It is there is no one size fits all answer to what is an appropriate resolution to an accommodation request. It is a facts and circumstances test that take into consideration the proximity of the worker to other coworkers, the proximity of the worker to the members of the public, the proximity of the workers, for example, in a healthcare setting, to vulnerable patient populations. Sometimes a masking approach would be okay. Sometimes weekly testing would be okay, although oftentimes you're most contagious early on when you may be asymptomatic. So a test is not necessarily going to be determinative. Sometimes, and depending on the circumstances, additional PPE may be required. And sometimes under the circumstances, in the most extreme situations, an unpaid leave of absence may be the appropriate accommodation for an employee who perhaps doesn't want to lose his or her job and is willing to ride out the most dangerous time periods of the pandemic. So that's, I wish I could give you a bright line test as to what accommodations are appropriate, but there is no real bright line test. So let's turn to OSHA obligations. This is the last segment of the program, and it's the one I made sort of facetious reference to it early on. The Empire Strikes Back. What will OSHA do? The Supreme Court's decision does not mean that employers do not have continuing obligations under OSHA. If you come away with anything from this last segment of the presentation, it's that employers do have continuing obligations under OSHA. We're going to explain what those are, and we're also going to give you some predictions about where OSHA may go. And if there was going to be any clearer indication of what OSHA is intending to do, it's from Marty Walsh, the U.S. Department of Labor Secretary, who basically said OSHA will do everything in its existing authority to hold businesses accountable for protecting workers. Now, what does that mean? Well, that means OSHA can do any number of alternative things. They can take an industry-specific approach with further rulemaking or regulation. They can pursue customary rulemaking. They can take another shot at crafting an emergency temporary standard, maybe this time for the meatpacking industries or other industries that are more vulnerable. They can decide that they're just going to use the general duty clause, and we'll talk about what that is. They can place greater weight on the national emphasis for program, where OSHA publishes newly required policies and procedures basically to protect workers in higher risk occupations. They can take a greater emphasis on protective equipment or masking. Next slide, please. So one reason that additional rulemaking or additional policies may be coming from OSHA is the fact that the public comment period for the ETS is set to close today, actually. And OSHA reports it's already received approximately 120,000 comments. I guess, how would you like to have to be charged with reading all of those? This means, however, that OSHA is well prepared to issue new regulations, either with a more focused emergency temporary standard or through traditional rulemaking. A recent notice from the agency indicates that it may be planning to issue new regulations, which will specifically address infectious disease in the workplace. And those regulations may not be limited just to COVID-19. Those of you who remember the late 80s and the early 90s, especially in a healthcare setting, will remember that OSHA issued a bloodborne pathogen standard, which did go through the regular notice and comment period. OSHA may pursue a similar route with respect to airborne pathogens, and obviously COVID-19 would fall into that category. Next slide, please. So the bottom line is that OSHA is not going to give up. They're not going to take their ball and bat and go home. They're going to continue to look for alternative paths to increase vaccination in the American workplace. The reason is Marty Walsh reports to the president, and the president has made this a priority. I talked before a little bit about the general duty clause, and we can talk about what that is. OSHA's general duty clause was part and parcel of the act when it was first passed in 1970 and signed by President Nixon. And it states each employer shall furnish to each of his employees, you can tell how old the statute is, employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious harm to his, I guess it should be the employer's employees. OSHA's ETS was published in part because of the recognized difficulties that OSHA anticipated in enforcing something as broad as the general duties clause on a site-by-site, employer-by-employer basis. I have another theory. If you have a fairly detailed emergency temporary standard, which identifies the various things you must do, OSHA is able to establish a violation of that standard by just showing noncompliance. Contrast that with a general duties clause violation, where OSHA is going to have to sustain its burden of proof with respect to any number of elements. Number one, it has to be a recognized hazard. Two, it has to likely cause death or serious physical harm. And obviously, it's going to differ from employer to employee, employer to employer, that is, work site to work site. So OSHA has, quite frankly, a burden of proof issue if they're going to rely on the general duty clause. Plus, they have the risk of inconsistent applications of that clause to various employers. And that's one of the reasons that the secretary attempted to implement the OSHA ETS. In the commentary that accompanied the ETS, the secretary said exactly that. The general duty clause largely would be ineffective. Next slide, please. Keep in mind also that without regard to the status of the ETS, employers still have and always have had record-keeping obligations and with respect to reporting incidents involving fatalities or illness where it is likely or possible that the illness or fatality resulting from the virus was contracted in the workplace. The key is whether the illness or the fatality was work-related. In that regard, if it is work-related and a determination has been made, employers must report work-related fatalities within 8 hours of finding out about them. Employers only have to report fatalities that occurred within 30 days of a work-related incident. In other words, something that comes up 60, 70, 80 days ago that you may have learned was work-related may not be the subject of a mandatory report. Employers also must report inpatient hospitalization within 24 hours of learning of them. Next slide, please. I spent a lot of time advising clients on documentation of work-relatedness, and it is very important in the event of a complaint about an employer response to an outbreak in the workplace. And I'll tell you that more often than not, if you're going to have an OSHA inspection now, even though the ETS is not being enforced, it may be in response to a complaint from an employee made to OSHA about an outbreak in the facility and the lack of any meaningful employer response. In that situation, you'll either face a desk audit or perhaps a visit from a compliance officer, and you better be prepared to demonstrate that you have been cognizant of the issues in the workplace and have taken appropriate steps. As we all know, the Omicron variant has proven to be highly contagious, perhaps not as virulent, but highly contagious. And it's difficult to determine with any certainty whether it's related to a workplace exposure or exposure in the general community. So I've always told clients, require employees to report positive results as soon as possible and track those positive results without regard to how it was contracted. Use common sense, talk to the employee and ask if he or she was exposed to individuals with symptoms who tested positive and where. It could have been at home from a family member. It could have been in a social engagement, could have been at a sporting event. Let coworkers know, obviously, that a co-employee has tested positive. You don't have to give name, rank, and serial number. But letting them know that a co-employee has tested positive and ask them to monitor their own symptoms to make sure that if they're feeling unwell, they should go home. This has been the advice we've been providing since COVID-19 entered the American society in March of 2020. And then you want to make sure that you can take practical steps and document the practical steps that you have taken to minimize further exposures in the workplace. And again, this is a facts and circumstances analysis. You may want to enforce heightened masking requirements and social distancing. Next slide, please. I want to return briefly to the general duty clause. The general duty clause could also be triggered by an allegation that you failed to follow local health directives. Lee talked a little bit about local and state health directives that are unaffected by the OSHA ETS, and ignoring those, an employer acts at his own peril. And as a result, it could result as support, at least, for a violation of the general duty clause. As you know, for restaurants in Chicago, for example, have specific COVID-related requirements, both under City of Chicago ordinances and Cook County ordinances. Would the refusal to follow those ordinances give rise to a general duty clause violation? They could. It'll be a piece of evidence. So what we've done is I know we're coming close to the end of our presentation. We've tried to accomplish the four things, giving you an overview of the Supreme Court, giving you an overview of the specific requirements of the CMS interim rule, give you an overview as to how the Supreme Court decisions would impact a variety of other issues, including the unionized environment, including state and local regulation. And finally, we've tried to give you some predictions of where OSHA might go. We have a few minutes for a few questions.
I can read a couple out to you if you want, Tom.
Yeah, I saw the last one. I'm going to scroll up from bottom to top. Should a COVID test be part of onboarding a new employee? That's a matter of policy for you now. Let's talk about private employers who who may decide to mandate the vaccine. Obviously, it's going to be part and parcel of your onboarding. But let's talk about a situation where an employer may not have a mandatory vax policy. Could you establish a different role or rule that you will only hire the vaccinated? And the answer is you can, subject, of course, to your accommodation requirements. A lot of people are surprised to hear that, but the law does permit it. And let's see here. Another question is, am I obligated to pay for any leave related to COVID as a healthcare practice, as I have less than 50 employees, so the FMLA or FRRCA doesn't apply? Well, first of all, any requirement under the OSHA ETS to give paid time off to get the vaccine, or paid time off as a result of an adverse reaction to the vaccine, no longer is applicable to private employers. However, whatever reaction there might be to the vaccine could qualify as a serious health condition, albeit temporary, and may trigger coverage under the FMLA. Now, that doesn't necessarily mean, as you know, the FMLA doesn't require paid leave, but it may be protected leave nonetheless. Were there any other questions, Lee?
Those were the two I saw.
Yeah, there's another one that says, we are still screening patients and visitors. Is this something that can stop? I'll flip it over to Dana, but I will tell you that as a private employer, a private medical practice, a private clinic, a private surgery center, my understanding is the CMS rules establish a floor above which private employers could self-regulate, which means that if you want to screen patients and visitors, you can continue to do so. Dana, do you have any thoughts on that?
Absolutely. Yeah, I agree with what you're saying. I also just want to mention that it would depend on what type of facility you are. I mentioned that for long-term care facilities, CMS is looking at infection rates within the facility itself for both employees and patients. So you're going to want to make sure to look at the guidance documents to make sure that that specific rule would not apply to you, and adjust yourself accordingly with your own policy.
We have a time for a couple. One is from one of our hospital VPs. What is the effective date of the stay on the OSHA ETS? The stay went into effect immediately. It is not applicable whatsoever. It's not going to be enforced, and is subject to further proceedings down at the Sixth Circuit. Effective as of the date of the Supreme Court decision last Thursday. And then an anonymous attendee said, how do you combat the attendance abuse by people claiming potential COVID exposure every other week and taking a week off? Well, keep in mind, the most practical aspect of that is if they're taking off, they're not getting paid, or if they're taking off, they're burning up paid time off benefits. So hopefully in many respects, it's self-policing. I will tell you that I haven't seen a lot of issues like that come across my desk. I think employers are pretty much doing a good job of implementing and enforcing these policies on an even-handed basis. And with that, we are actually 1 minute prior to the termination of the webinar. I'd like to thank everybody on behalf of Dana and Lee for being attendees today, and we hope it's been very helpful to you. Thank you very much for attending.
Thank you, everyone.
Thank you. Bye.